Good afternoon, everyone. This is Igor Roitburg. I am the President and Chief Operating Officer of Default Mitigation Management. And on our webinar this afternoon, we also have Joshua Cohen. For those of you who don't know Josh is one of, if not the preeminent student loan attorney in the country. In addition to representing his own clients, Josh goes around the country and helps educate other attorneys on how to do student loans. Also with Josh, we've got Jeff Cohen. Jeff will speak to us at the end of the webinar, towards the end of the webinar, about how you can integrate student loans into your practice and hopefully make it a profitable portion of your practice. Before I turn it over to Josh and we get started talking about student loans, I just want to talk a little bit about some of the ground rules. Most everyone here is muted, so just make sure if you want to ask a question, there should be a little bar in your webinar here that allows you to ask a question. Please do that, and we'll try and get to them as quickly as we can. And hopefully there'll be a little bit more time to open it up for questions at the end. Also, just real quickly, most of you guys, because you're from the DMM portal, you are bankruptcy attorneys. And I know that the much discussion has been had in bankruptcy about discharging student loans, and a lot of people think that that seems to be the only game in town. What hopefully we'll get through to you today is that there are other options for you and your clients, and there are ways that you can help your clients in bankruptcy and out of bankruptcy, and hopefully in due time with additional programs in bankruptcy as well. So right now I'm going to turn it over to Josh and have Josh speak to you a little bit about student loans and how you can help your clients manage them better. Josh, I'm going to make you the presenter in just one moment.
Hello, everybody. Okay, and I'm just getting all set here. Okay, so what we see in front of us is the login screen for StudentLoanify.com. But before we get there, let's talk about me for a quick second. My name is Joshua Cohen. I am the student loan lawyer. I am now in my 11th year of practicing student loans, and it's all I do. Believe it or not, I always want to do bankruptcy, and then I start talking to some of you guys, and I realize, no, I don't want to do bankruptcy. So Igor alluded to the idea of discharging student loans inside bankruptcy, and for most practitioners I've worked with, we know that that's really hard to do. There is new theory out there, actually not theory, it's actual practice, that if you find some truly private loans, they might be more easily dischargeable. They don't fit under the definition of 523A8, but that's a narrow line of them. What you have in front of you now through StudentLoanify is a tool to work with federal student loans, which have been around since, well, before most of us. And you've done bankruptcy work. You may have come into a discharge once or in a while through an undue hardship, or for those of you in the 8th Circuit, totality of circumstances, or for those of you in the 1st Circuit, you don't have a guideline yet. But for the most part, you think student loans, federal government, what am I going to do with them? Well, congratulations, we now have a tool for you. StudentLoanify.com is going to walk you through everything you need to do, and when you're done, it'll tell you what you need to do to help your client. And the best part about this is you don't have to be in bankruptcy. Even if you're outside of bankruptcy, this will help you. Think of all the people that have come into your office that have a student loan issue that maybe don't need a bankruptcy or don't qualify. Now you're still making money because you can still help them with their student loan. So we go through, and I believe through the DMM portal, there's the ability to go straight to the StudentLoanify site, and we go to log in, and we'll do this live. Don't use my credentials because that won't work for you. One second. If I can spell, things work easier. We all know that. And so we log in. And so this is the opening screen, and I have borrowers. You can see I've got 6 pages worth because I've been using this system. When we come in with the new person, this actually has a full intake for you. So what we do is we go to Start New, and then we hit the Professional for $99 right here, select. And what it does, as soon as it comes up, this is the client setup right here. All you need are 4 things: borrower's first name, last name, their email, their phone. You hit save and continue, and it will email them an intake form. And I'm going to show you what it looks like on the back side by showing you an existing person that I've set up for this purpose. Her last name is Defaulter, for obvious reasons. And I do a search, and Barbara comes up here. And this gives me a status here. You can see it was created back in January and updated back in January. But it shows me here, completed docs available for download. It tells me that the intake form has been completed. So we click on her, and it comes in. This is the screen that you will see after Barbara finishes her client intake form. But what we're going to do is we're going to skip for now, and I'm going to show you what it looks like from her side. So it would start with the welcome screen, where Barbara can verify all of her information, her first name and her last name, her email address, and her phone number. And then it walks you right through. Starts with student loan discharge information. And basically, it just has very brief things, and if you click on any of them, it gives you a brief description of what it looks like. It won't say download form on the intake form. Instead, it'll just give them a checkbox so that when you get a report, it says, hey, look at this. Since it's completed, it gives me as the attorney the option to download the form. So we start with the student loan discharges, which of course means you can get rid of the loan you get rid of it within 60 days normally. And then it doesn't matter if they're in default or if they're in good standing. Just a quick way to get rid of it if they qualify. The next part, we look at collection activity, and we'll also ask about bankruptcy. Now, this is a person who says that they're in an active bankruptcy down in Mississippi, and that we made up a case number, and they're in Chapter 7. And does the borrower have court permission to work on the bankruptcy, work on student loans in bankruptcy, because there are some things that trustees and judges are allowing. You also have the ability, just like I'm doing right now, to come into the form afterwards to double check what they put in there and correct anything. So if they've come into your office and they haven't actually filed it yet, you can click no. So you can fix it. We'll go back to yes. Wage garnishment. Are the borrower's wages currently being garnished? Well, if they're in a bankruptcy, it's actually a no. We want to know what's going on right now. Lawsuits and judgments. Are they being sued? Is there a judgment? What's going on? Okay. And then we go to family. We're going to say no. Family size. How many children, including unborn, are in the borrower's family and receive more than half their support? And if you need a definition, your client gets this as well. So if they're not sure what it means, here it is. And that's directly from Department of Education. This person has 2 children. Are there any other children? And here again is the information, what it means. And this person has no one else living there. This person is married, but they're one of those married couples where they separate their finances and they can't even get their spouse's financial information. So we check this box. This person lives in Mississippi or is a resident of Mississippi. And then we go to employment type. Now, the point of this here is to find out if we can get any loan forgiveness based on their employment, either public service loan forgiveness or teacher loan forgiveness or both. So we're going to abbreviate the questions, but it will always respond based on their answer, and it will take them all the way through to find any potential way that they might qualify. And if they don't, it'll say, and if they do, it'll say, so that later on we'll come back to it. Then we talk about income. Has the borrower's income changed since they filed their federal tax return? Here they say, yes, it has. And what is their income? First, do they still have taxable income? Maybe they check this box because they've since become unemployed. So down here, they would say, no, they don't. This person has a change in their financial circumstances, but they're still working, so they say yes. And their annual taxable income, this person makes $35,000 a year. And then we go to the student loan data. Now, for those of you that have taken my course, you know all about the National Student Loan Data System right here, NSLDS, which is really the credit report of federal student loans. It's a database run by the Department of Education, and it has all the history on federal student loans. It doesn't have an accounting, but it does have loan information. And for those of you who aren't familiar with it, here's what it looks like. So if you like the matrix, here you go. And this was actually a shorter NSLDS, but some of them go on for quite a long time. And if you like to read code, this is great. But if you don't, you do it here. Again, this is part of your client's intake package. It'll ask them to either use their credentials to log in, and it'll automatically upload. Those credentials are not saved, so there's no security issue here. We don't know what they are if they use that. The other option is if they already have it downloaded, they can upload it as a PDF file. Sorry, not as a PDF, as a TXT file. But all the options are there when they get the intake form. It also tells them how do they do it. You click it here, and it shows them. Okay, how to download it. Bing, bing, bing. Okay. From there, we come to the analysis page. So we start with our current loan status. This person has one outstanding loan for $40,668. It's in default. That's why she's Barbara defaulter. It's again for $40,000. She has nothing in deferment, forbearance, or grace period, nothing current. But let's actually look at the analysis. So if we click this button.
Josh, before you do that, can you go back? I just want to point something out to everybody while you're going through this so that everyone's aware of how you got all that information. Yeah, right there on step one. One of the things that it's important to understand, and we all know that some of the challenges we have in getting information from our client, once they either connect with their NSLDS file or give you the TXT file and upload it, what you see here and all this information, it's automatically created for you. You don't have to input anything, and neither does your client. That's pulled directly from the NSLDS, and you get a brief summary. And Josh will show you a little bit more now about the student loan analysis and how that actually pulls directly from the NSLDS database without you having to actually know the exact information about the loans. Sorry, Josh, just want to make sure that they knew where it was all coming from.
Yep, it takes this and it turns it into what you're about to say here. Now, where this starts off is what you're seeing now when we printed the analysis. This is for the attorney. This is for you. And you can see it's prepared, well, this is for my law firm by StudentLoanify. Thank you for using StudentLoanify, and here's our quick summary. We have our total loan balance right here. Loans in good standing. No, Barbara does not have any loans in good standing, but we do see she's eligible for forgiveness. It might be teacher loan, might be public loan, might be public service loan, might be Perkins loan forgiveness, might even be IDR forgiveness. Again, that's broken down in a minute. Is she eligible for any discharges? Well, she didn't say anything that would make us think she is. Other things to pay attention for. She said that she has a wage garnishment. She also said that she's in a bankruptcy. Something's wrong here. It's usually one or the other, or perhaps the bankruptcy stay hasn't hit the garnisher yet. But as a bankruptcy attorney, you folks know how to deal with that issue. Now we go to the instructions. Okay, right here, big red letters. We have a loan in default. Now, because this one we checked the bankruptcy box, it's going to tell us how do we want to deal with this loan in a bankruptcy. And for Chapter 7, it'll give you some more information. I'm not going to walk you through all of that. But it gives you some of the options real quick, sorry. So if they want to settle, what you'll have to do. If they want to rehabilitate, what they want to do. Excuse me. And then it talks about what the rehabilitation payment's going to be. And if you do it, it literally walks you through it with the checkbox. If the $48 is not affordable, what can they do? All of this is here. But wait, it gets better. If you're doing a 13, we give you some more information, but this only applies to districts that allow rehabilitation or consolidation during Chapter 13. And this is based on some test case out of North Carolina. It's called Buchanan language, which Ed Boltz was able to work. And this has been thriving in lots of other districts where you can write into your Chapter 13 plan, what are you going to do with the student loan? Well, if you run this before you file, it'll give you all of those options. So this talks about rehabilitation in a 13. It talks about consolidating in a 13 with the full checklist. We don't settle in a 13. That's usually frowned upon by the trustee. And here you go. The attached consumer report is intended only if they're doing a 13, because it won't be applicable for a 7. If you read above, when you get the report, you see why. So now you also have a tangible for your client. This is a federal student loan analysis created for Barbara Defaulter on today, the 29th. Prepared by who? By me. StudentLoanify is not in here. This is all white labeled for your law firm. This is your work product. And again, it walks them through, and you want to read this before they do and make sure you're on the same page. So, but this is worded for Barbara, okay? And this was based on information she submitted back in January 25th. This is this. If we give this to them, their eyes spin. If we give them this, everything makes sense, because this is all they really want to know. We have a direct plus parent loan that's with debt management collection services. The principal balance is 27, the interest is 13, the interest rate is 3.16, which I got to tell you is a really good interest rate. It is defaulted. All of this came from here. Okay? Warning, loans are in default. Okay, so now Barbara knows she's in default. I don't care how she came into your office, she now knows she's in default. All right, and we talk a little bit what that means. All of these things is what can happen to her if she's defaulted. She probably came in because of one of these, like perhaps a wage garnishment. Why should you deal with it? Well, there's 3 ways to deal: settlement, rehab, or consolidation. We talked about settlement, and this right here will tell them why they're not going to do it, because it's 90%. Most people don't have 90%. Talks a little bit about rehabilitation in language they can understand, including the 16% fee if they decide to rehabilitate. Talks about reasons why rehabilitation might be your only option. And then we go on and talk about consolidation, and that if you do consolidation, you must choose an income-driven repayment plan. There are 5 different plans, which we'll get into in a minute. And here they are. We have repay, pay, IBR, IBR for new borrowers, and ICR. Notice something here: not eligible for repay or pay or income-based repayment. But for ICR, they are, and consolidation is required. And for those of you that have already guessed why, she has a Parent Plus loan, they can only have ICR. So this does a lot of the thinking for you. You don't have to go back to my manual and go, wait a minute, what are we doing? It does it for you. Okay, so we know that she can do ICR. We know the payment will be $237 a month. Now, here's the beautiful thing. If you're not doing bankruptcy, you get the same results. You already know the payment's $237. If you're looking at doing Buchanan provision in a Chapter 13 plan, you've got the ICR number. You already know what to plug in. Important disclaimers, some information. This is CYA for you guys. Then we talk about public service loan forgiveness, because this person qualifies for it based on the way they answered their employment jobs. And it talks more about it, lets them know only since October 1st, 2007. It doesn't matter that they've been there since the 90s. We only care back to 2007. Payments only qualify if they're made on time within 15 days. FEL loans don't count. Perkins loans don't count. But if you consolidate, they do count. If you're already making qualifying payments, be careful, because if you reconsolidate, you start from 0. So we've done what we can to make sure the CYA is in there and to educate your client about what's really going on. And then we talk a little bit more. Do you have a qualifying employer? Sounds like you do. Are your loans eligible? No, because you're defaulted. If you fix that, we're good. After that, you need to make payments, 120 of them. And then how do you apply? Again, the form is out there now. You do it after 120 payments. Then we talk about some just general considerations for consolidation. Here are all your pros, and here are the cons. You lose the ability to pay off the loan one at a time. Some of your clients want this. Most of them don't care. Restarts the forgiveness clock. Again, most of the time they don't care, especially if they're coming out of default. But here, one servicer, one bill, one payment. That's a great advantage. Qualify for additional loan plan payments. She only qualifies for income contingent if she consolidates. She gets to pick her servicer. If she doesn't like one of them, she can pick another one. Gets the loan out of default. That's the chief reason this one we're doing consolidation. Locks in an interest rate if it was variable. and it does reset the term to 25 years. What else? And then we throw this into all of them because people will ask, should I refinance my loan with a private lender? And my answer is almost always a no. Here's some reasons why. You lose all of the income-based payment plans. You lose the ability to get your loan out of default. You lose the ability to discharge due to disability or if you die. Private loans can go after your estate. You also lose the forgiveness plans like teacher loan forgiveness, public service loan forgiveness, and also the IDR forgivenesses. So yeah, you might get a lower interest rate, but at the end of the day, it may cost you a whole lot more than you realize.
Josh, I'm going to ask you to pause here for a second because I think for those folks that aren't 100% familiar, can you spend a couple of minutes just explaining what IDR forgiveness is? I think a lot of people have heard about the public service loan forgiveness, but for those people who aren't expert in the subject matter, maybe give them, a quick 30-second primer on, how IDR forgiveness works so that people understand what that is and how that can ultimately help their client in dealing with their student loans.
I thought that's a different webinar. Okay, so with income payment plan, thank you for that, Igor. Income-driven repayment is an umbrella. It includes 5 payment plans: revised pay-as-you-earn, income-based repayment, income-based repayment for new borrowers. It's like New Coke. They couldn't think of a better acronym. And income contingent repayment, ICR. ICR has been around the longest since 1993. IBR came out in 2009, yada, yada. With all of these plans, whatever isn't paid off within the term, either 20 or 25 years, is forgiven. It gets written off. Right now, the way the law is written, your client will be issued a 1099-C, a cancellation of debt. Do they have to pay taxes on it? I can't tell you because I'm not a CPA or a tax attorney. If you have a tax practice, Jeff's going to talk about the wonderful things you can do with this. If you don't have a tax practice, that's okay. There are accountants and financial planners you should be working with because this is a good referral network back and forth. Again, at the end of 20 to 25 years, depending on which plan they pick, anything not paid is written off. And you can see why. If this person picked a repay plan, if they were eligible at $32 a month, how much is $32 going to pay off in 20 years of payments? Is it going to pay off a $40,000 loan? Not necessarily. So they will have a balance. IDR also allows for negative amortization, meaning you're paying less than interest. That's crazy, but it's allowed. This is what Congress came up with. Now, the other thing about an income-driven repayment plan is your client does have to recertify their income every 12 months. Jeff's going to talk about some good things about this as well. It means you're going to have this client for 20 years. Not like a Chapter 13 client that's a serial filer. It's different. You're helping them stay on their payment plan. If their income goes up, their payment goes up. If their income goes down, payment goes down. Of course, it never goes lower than 0. No, there's never a time when they will pay you for having a student loan. Ha, ha, ha. It's a good joke, though. In answer to the logistics professional that came to me and said, do I have to send a check if it's a $0 payment? No, you don't. So you can see these payments are very helpful. And yes, it is possible to have a $0 payment. You will see this quite often with your lower income folks or people with large families and mediocre income because it's based on family size and adjusted gross income. So Igor, did I hit all the points you were looking for?
Yeah, absolutely. The only thing that I would just add is just to contrast it a little bit with the discharges. I know a lot of the bankruptcy folks always talk about the discharges, and it's obviously great to be able to get rid of your loans wholesale if you can. That's usually unrealistic and very difficult to do, and getting them on an IDR plan often is a very realistic and reasonable way that they can stay current, not be in default, keep their credit up, and continue, living a life with these loans without being put in default, without dealing with administrative wage garnishments, et cetera. So just, I know a lot of folks always talk about the discharges, want to make it clear that this is a great opportunity to maybe not discharge a loan, but certainly put your client in a position where they're managing their loans and surviving and dealing with their debt in an effective way.
Let me go a step further and say this right in front of you, these repay and pay and IBR. This is why people lose adversary proceedings. if your client walks into court and has a payment of $32 a month, and prong number one is paying the loan, that your client can't maintain a minimal standard of living because of the $32 a month payment plan, that's a really hard argument. This is the first thing that DOJ or ECMC throws back at your client. So my rule of thumb is start here. And if your client can afford it, I don't know that an adversary proceeding for discharge makes sense. There are, of course, other things to look at, but this is the first one. And quite honestly, putting them into a $32 payment or whatever it is also cheaper than filing an adversary. I don't know what any of you charge for adversaries. I'm not going to go down that alley, but I got to tell you, this is going to be a whole lot easier. Again, Jeff's going to talk about monetizing this as well. So with that, once you've done all of this, we go back to the website. We've done step 2, the analysis, and then we go to 3, the repayment plans. And here we picked, notice it doesn't actually let you pick any of these plans because they're not eligible for them. They can't have the standard plans coming out of default because of the consolidation, the way it works under the law. They can't have repay or pay as you earn or IBR for new borrowers. This particular client has Parent Plus loans. They can only have ICR. So we picked it. And once we do that, we begin the application. And our application is already done through the intake process. We have everything. We understand we're going to be on ICR. Yes. You pick your servicer. The servicer. Your loan is going to be with Department of Ed, which gets picked the servicer. Who do you want your bills from? And then we confirm that you're doing an ICR plan for $237 a month. We hit apply, and boom, here are all the applications. Okay, the consolidation application's here. We hit that, and it'll come up. IDR plan comes up. Proof of borrower income comes up. And this also gives the public service loan forgiveness application. If you hit the download checklist, this is awesome. It takes a few minutes to put it together, but it is awesome because, come on, and if you're billing by the minute, this is also good. What this is doing right now is it's populating all of those forms, and it comes up with everything we need. You can print it out right there. If you're doing face-to-face analyses with your clients, while you're talking to them, they say, yeah, this is what I want to do. You click the right buttons. This comes up, and then I'm going to pull this up in the bigger screen. Give me a second here. And there you go. Your document checklist, application for the consolidation. These are the instructions. Make sure you review it. Sign and date page 5. Where are you sending it to? This person will pick Fed loan. Okay. It is all pre-populated. You're going to run through it all and make sure everything's correct. Bob is referral number 1. Rob's referral number 2. You must have references. And look, it does all of this. Now, those of you who've done consolidations, you know the hardest part is getting the loan code. This does it for you. Okay, you don't need the loan account number. I've been doing this 11 years, never filled one out with the loan account number. Okay, fills out borrower's name, their social, everything is there. And then we go to page 5, and oh, wait, it's not signed. Of course it's not signed. Your client doesn't sign through this. You print it, they sign it, you date it, boom. And let me show you. It also gives you the income-driven repayment plan request. Again, review and confirm. We're looking for page 4 to sign it. Everything is here. Checkbox. We're going to enter an IDR. We're entering ICR. It does everything for you. 2 kids, nobody else. Married but can't get information, so it guides us straight through. Has your income changed? Yes. Do you have a taxable income? Yes. And then we scroll all the way through to the signature page. Again, print it, sign it. Good to go. This is the rest of the documentation. Instructions for income documentation. You have to document all taxable income. It gives you an idea of what you can use. How to document, again, different methods that you can use based on your answers. Again, you're sending it all together. And then public service loan forgiveness. This only shows up if they said yes to public service loan forgiveness. If they didn't qualify, you won't see it. It's all good. this is the employer certification form, which is pre-populated. You can print it out and give it to your client, and they can do it right away. Okay? They take this, they give it to their employer information, and they fill out all of this to confirm that they do qualify. And they'll do that every year, as well as recertifying their income every year. And this is, we're giving you the application now. They might need it. Depends how close they are. You may have people that come into your office that are already qualifying for it. Well, here's the form. And that is everything we need. You get out of there, and you have now completed your first client through StudentLoanify. Whether you're doing bankruptcy or not, they've been consolidated, they're out of default, they're on a payment plan, you got paid, everyone's happy. Jeff?
Thank you, Josh. Can you hear me okay?
Jeff, before you jump in, there have been a couple questions. So just to make it sort of run together, Josh, let's go through a couple questions that hopefully you can answer real quickly here. So first question here is, this is a lot of info for the debtor to complete. We definitely have to have them come into the office. It's certainly one way to do it. I will tell you, and having done this with several attorneys, it really isn't as challenging or as complicated as it seems. They get a link and they simply respond in kind of like a TurboTax fashion, where they just answer relatively simple questions. Next question, Josh, I think this will be for you. What if a defaulter wants to pay a lump sum payment with money donated by family and friends? If so, how low and how determined? I think that's a specific case. I don't know how you want to answer that, Josh, but I'll leave it up to you.
That's actually in our analysis. You're never going to get a settlement better than 90%. So if they owe $100,000, they can settle it for $90,000 due within 30 days. There is no negotiating, especially under the current administration. They got rid of the hardship rules too. It's 90% or you're not getting anything.
Thanks, Josh. Next question, I think I can answer this. This is, at what point do you pay a fee for this report? And what happens is, in the pro version, after your client has completed all of the information, you're going to get an email back, and that email is going to tell you that they've completed that information. When you go to pick up their analysis and all their forms, you will pay at that time. And again, you'll process everything like you typically do these days, just online, submit everything, and it will automatically process payment for you. Someone's asking whether or not we'll be able to print this presentation. There's not a print version of it, but we are recording this and we will be posting it online for other people to review. Jeff, this will be a good lead into you, so we're going to table this in just a second. The question is, how much should we charge for the service? Jeff will talk about that in just a little bit. What if, okay, this is a question. Can we use our internal email with them? Question here is what if someone doesn't speak English? Can we use our internal email and prepare with them? Actually, what you can do is you can send them the link, and once you set them up, you can stay within your own StudentLoanify profile, click on their name, and help fill it out for them. So you don't actually have to enter their name and try and game the system. Just send them the email so they have a record of it, but you can go in and update the information with them. Okay, next question. What if, okay, how are you going to get paid? Yep, we'll talk about that. If borrowers
I prefer cash or check.
Josh, if borrowers being garnished, do we need to provide documentation to stop the garnishment, or does the garnishment automatically stop once the paperwork is approved? Josh, I think that's in your wheelhouse there.
Okay, so what you're going to find out, if you don't already know this, it's kind of nasty, you can't consolidate if they have a wage garnishment. So the only way you're going to deal with that is through a rehabilitation, or if they have other reasons to file a bankruptcy, this is collateral benefit, it will automatically stop the garnishment. But you cannot consolidate if they have a wage garnishment. You can request a hearing, and they should have the notice on that. I got to tell you, if my client can afford to pay my fee, the garnishment hearing is usually a waste of time.
And also, Josh, I don't know if you want to mention to them, I know that in our report, when a wage garnishment is flagged, we help give you some guidance as to how you can address that wage garnishment for your client and get them in good order, so that then you can move back and proceed with the consolidation after you get rid of the wage garnishment. So that will be in your instructions if that's something that's flagged. Okay. Next question is about how we advertise as well. So Jeff, I think this is a great opportunity for you to step in and talk a little bit about how these folks can incorporate this into their practice and make it hopefully a very profitable division of their firm.
Excellent. Thank you, Igor. Okay, so my name is Jeff Cohen. I am not an attorney, but I help attorneys succeed with their businesses and use their talents to actually monetize the work that they do. So student loans is an interesting niche compared to other types of law, because it is a niche where you do not need to do free consults. Okay? I think a lot of people who are in the bankruptcy area, typically you do a free bankruptcy because the guy's going to visit you and then visit 3 other attorneys in your neighborhood and try to find the best price, things like that. With student loans, that's not the way it works. People are typically looking for help because they have a need that they need to get serviced, and usually they wait to the last minute for it to occur. So we tell people, first thing is, you want to charge for your consult. And the question is, what does the consult include? Well, the consult includes sending the intake form to the client, having the client complete it, having the client upload their NSLDS, and producing the analysis that Josh just took you through. And then you delivering the analysis, going over their options with them, is the paid consult, because at that point, you're delivering tangible information with options for a solution for their specific scenario, and that is worth money. Okay? Depending upon what area you're in, you can get away with anywhere from, we've seen some people charging $175, we've seen other people charging upwards of $300 for that consult. And some people are doing the consult as a half-hour consult, some people are doing it as an hour consult. My suggestion to you is, because the analysis is going to provide you with a lot of specific information, a half an hour is fine. If you spread things out into an hour, you're going to end up most likely dealing with the what-if game, which is really a lot of wasted time because there are no what-ifs. Everything you need is in the analysis. So our recommendation, start off with an hour as you get used to things, but really you want to do half-hour consults. So with the fee structure, you as a StudentLoanify Pro pay $99 to StudentLoanify for the full analysis, the legal information that it's assessing with you, the branding of the analysis so that it doesn't say StudentLoanify, and the capability to use the intake form. So if you're charging that $250, you're still clearing $150 during that 30-minute consult that you want to get yourself to. From there are a variety of different ways to charge. Some people will do the consult. Once the consult is done and the client has said, yes, I want to do a consolidation, yes, I want to do a recertification, or I want to do rehab, they charge different amounts. And those prices can range from, a consolidation can be, most often we're seeing it in the $800 to $1,200 range for a consolidation. Rehabs, we're seeing in the range of $1,200 to $1,800 for doing the rehab. And you might be scratching your head going, but with StudentLoanify, it only takes me like 20 or 30 minutes to do that. And the answer is yes. Isn't that profitable? Right? You're getting so much of the process done during the intake that doing the consolidation or the rehabilitation afterwards is mostly about communication, not about legal work or law work. So some of the companies, they're charging that money and then they're handing it to their paralegal to basically do the follow-up, finalize everything, and send the paperwork out, and then doing the follow-up contact management. So it can be extremely profitable if you're using StudentLoanify, because you're talking about potentially $1,000 for a consolidation that takes you less than an hour to perform. The key to student loan work also is this. When a person is on an income-driven repayment plan, they have to recertify for 20 to 25 years. That means that every year you can contact your client, say it's time for your recertification, do another half-hour consult to determine if their wages have changed, their earning has changed, have they retired, have they had a child, has their income situation or their family situation changed, And that means that you get that client on the hook, and every year you're doing another $250 recertification. Year 2, $250 recertification. Year 3, $250 recertification for 20 years. That is the only area of law that builds you long-term recurring revenue. So you can see that if all you did were consults and recertifications, you can retire in 5 years generating about $150,000 a year, and all you're doing is maybe 25 half-hour consults a month. It's pretty nice sounding, I think.
And also, Jeff, to echo a little bit of what you said in terms of the recertifications, one of the things that StudentLoanify does is, in addition to giving you the original application materials for you to actually enroll in a specific plan, once you've determined what that is, we'll also give you notifications and alerts as to when your clients are ready for recertification, and you'll be able to get the recertification applications completed for you through StudentLoanify as well, so that you can then just simply have them, sign it and then send it in. So a lot of administrative work that goes into getting that recertification and even the calendaring is done for you.
Thank you, Igor. So that's sort of the fee structure and the charging. Approximately $250. As you know your market, you can decide what range of price that initial consult should be, but you should be charging for the consult. If you do a free consult, you're going to be overloaded with so much information that you're going to end up doing all of this work anyway. It doesn't make any sense that you should be doing this for free. Now, there was a question about advertising. How do you advertise this? Well, the first place to start is with your existing customer base. 1 in every 4 of your customers already has a student loan. And this is important, you do not need to be delinquent or in default in order to work with them on a student loan. If you have a person who's paying their student loan fine, but they now want to buy a house and they're failing the debt-to-income ratio, you can help them get on an income-driven repayment plan that could reduce their monthly payment, helping them to improve their ratio to purchase a house. And other things that are helpful for you and your customers is this. Just because you get on an income-driven repayment plan where your minimum payment is lower than perhaps other payments, they can still pay more if they want to pay off their loan faster. Putting them on an income-driven repayment plan increases their flexibility with their budget. So, for example, if they have to pay $500 a month, but on an income-driven they only have to pay $200, they can continue to pay the $500 a month. But if a life event occurs and they need a couple of months of reduced payment, they're already on an IDR, their minimum payment is only $200. There's their flexibility. You do not get that flexibility on a private loan. You only get it on a federal loan. So income-driven repayment plans can be used for people who don't have any default, but it still offers them a benefit. And if you are working with a financial planner or a tax planner, this is a good partnership arrangement to help them understand how the flexibility of their student loan can help them plan for retirement, can help them oscillate their funds based on what's going on. They're getting ready to pay for students in college, so they need to move things around. There is flexibility in the federal student loan system. And working with a tax planner or financial advisor builds you a referral network, but also increases your customer satisfaction. So my suggestion is you market first to your existing clients. Say, hey, I can help you with your federal student loans, even if you're not in default. If your payments are getting tight, your budget is tight, you have certain things going on, give us a call and let's set up a consult. And it's a great way to market. Think about student loans. Sure.
The other thing is when you're advertising to current clients or past clients, you don't have the ethic restrictions on advertising. They're already an existing client, and that makes, in certain states, things flow much quicker and easier for you.
Yeah, thank you for that, Josh. That was an important note. The other thing is that student loans are very funny. Student loans have people have sort of this pride about them, about how much they owe. Right? If you go into a room and you say, how much do you owe in student loans? People will compete to see who owes the most money. It's almost a bragging right. So when somebody there goes, I don't know anything because I got on an IDR payment and so attorney helped me, it's going to gravitate referrals very quickly for you. If you walked into a bar and you said, oh, you know, I do student loan law, people would be like, what does that mean? But if you walk into a bar and you said, I can help you save money on your student loans, more people will come visit you than any other legal stuff going on, because student loans are in such populace. Everybody talks about them, and everybody thinks of them as a bragging right. I mean, we went in, and I can't remember, Josh, you and I were somewhere, but we mentioned that we help people with student loans, and all of a sudden there were like 8 people, you know, all talking about how much they owed and who owed more and the war stories that they had. And as soon as they found out that Josh could help people with student loans, he got every single person's name in that area. So it is very easy to garner business, word of mouth, referrals. You don't have to spend money on pay-per-click. You don't have to go crazy over social network marketing. Work your existing customer base. They will bring you business because they'll be very happy with it. So it's a highly profitable area of law. It is a recurring revenue area of law, and it is a very viral area of law where lots of people will talk and the referral network will dig. So it is easy to monetize student loans. Anybody have any questions on the sort of business side of things?
Yeah, we got a couple things here. First, so there's a question about recertification, which is a little bit more substantive than it is about business, but let's make sure that people who are on the line understand the answer to this. So with the income-driven repayment plan that Josh went over and that Jeff alluded to, what happens is the borrower, instead of paying off the balance of the loan, they pay only a portion of what is their discretionary income, and there's a formula for computing that. But ultimately, what it means is they pay a much lower amount. But because it's based on your income, what happens is every year the government wants to know how much you're making, so that if you're making less, that payment will go down. If you're making more, that payment will be reflective of that as well. So the recertification is essentially an application that you have to submit to the government, showing them what the income is in that current year, so that to the extent that there need to be any adjustments to the payment, they are made at that time as well. So that's what that recertification is. It goes hand in hand with the original application, and it's just a way to make sure that you can stay on it. And Josh, correct me if I'm wrong, if there's a failure to recertify, you lose the income-driven repayment plan and then are put back on the standard plan, which is essentially a 10-year amortization, full amortization of the loan.
Yes, so let's put some caveats there. One, you can still reapply for IDR, which is good. The bad news is the interest that accumulated during the period you're on IDR, when perhaps you're in the negative amortizing, if you miss the recertification date, it capitalizes. But if you spend all 20 years on IDR and you always recertify in time, the interest never capitalizes. You will walk out with the same principal you walked in because you barely paid any interest, but it never capitalized. And that's very important for people.
Thanks, Josh. Hold on, Igor. I just want to put this. So I think that we should put it in numbers for people. So to give you an example, Josh, can you pull up the payment plan options for Barber default that you showed earlier? So you can show people what the standard plan amount was versus the post-consolidation amount.
Yep. Give me a second here. We go.
While Josh is doing that, the importance of interest not capitalizing is this. At the end of the loan, the amount that you receive your 1040K on that might be taxable after 25 years is based on your principal, not your interest. So if your interest never capitalizes, it's never showing up on that 1040K. And that is very significant.
Okay, so I pulled it up for you.
Okay, so the standard plan, which is the 10-year amortization plan, shows a payment of
$470
off that payment. Okay, and after $470, and after the consolidation, her payment would be.
Well, unfortunately, because she has a Parent Plus loan, she can only bring it down to $237. If this wasn't a Plus loan, they'd crush it down to $32.
Yeah, but even with the $237, so she's saving over $200 a month. So over a 20-year period, that is basically about 200 times 12 months is 2,400 times 20 years is $48,000 basically that she's not paying. Okay, if she recertifies every year, then it's that 48,000 that's on the 1040K. If she misses the recertification, then all of the interest on that 48,000 also appears on the 1040K. That's why making sure recertification is important. Making sure it gets done on time, that you don't miss it, is very important to what happens at the end of that 20-25 year period. I just wanted to point out in numbers basis. Okay.
Thanks, Jeff. A couple of other questions here related to whether or not people can do this by themselves or do they need assistance. You know, our response to this is always to sort of liken it to tax returns. Anybody can fill out their own tax returns, but you probably don't want to be doing that. Most of the borrowers, I mean, there are obviously people who are very much in tune with what's going on with their student loans, know where every penny's going, know every single nuance of every single program that's out there. The reality of it is, out of the 45 million or so student loan borrowers out there that owe $1.5 trillion on their student loans, the vast majority of them couldn't even tell you who has their loan. So the answer is, yeah, in theory, I guess they could go out and do this on their own. But in reality, a lot of them are looking for assistance, are looking for guidance, and there are certain things, particularly for people who are in default, who don't know how to get out of default. And there's, you know, sometimes consolidation is a great option, but sometimes they have an administrative wage garnishment. Sometimes they need a rehabilitation. Sometimes there are other things that, frankly, they just need some guidance on. And with StudentLoanify's tools, as well as your ability to represent them, a lot of people just are looking for that guidance. And so, yeah, some people can do it, but most people can't actually do it, nor do they want to.
Let me give you proof is in the pudding. I've been doing this 11 years. All I do is student loan work. Do they need me? No. Do they want me? Yeah, they do. And they want you too.
Yeah, and along those lines, you know, there are a lot of people that you know, that contact us, and they're all looking for assistance. They, you know, they're unsure of the process, and they want someone to help them throughout it. Okay, Jeff, do you have anything else? Because I think we're getting close to the end of the hour.
No, I think those are the main things. Obviously, if people want more information, they can contact us, and we'd be happy to, you know, answer other questions afterwards. But I think if there's more questions coming in, we should address those.
Okay.
Hey, Igor.
No, I think yes.
What can they do if they really want to learn more about student loan work and just gear up and learn all of the nitty gritty? What do you think they can do?
I was just about to get to that, Josh. For those of you that want to become real experts on this and get into the details, Josh runs webinars. Not webinars, workshops, and you can attend one of those. And Josh will certainly be able to educate you on some of the nuances and the finer points of that. And Josh, you want to tell them where they can find that information?
Well, I thought you'd never ask. Yes, you can find the information at StudentLoanLawWorkshop.net. We still have quite a few dates left this year, and we'd be happy to see you there. And we have lots of graduates. We've actually do have quite a few graduates come through to get refresher courses, because one thing we don't talk about here is borrower defense to repayment. I don't know that that's a big thing, but for some of you that are in places that have a lot of for-profit schools, this is becoming big, and it's an area that, you know, you could be on the forefront of.
Terrific. Thanks, Josh. Okay, so just a couple of final parting notes. Since most of you are DMM portal users, because that's how we found you, that we sent our information to only our users, know that as long as you have an account to the DMM portal, you automatically can log into StudentLoanify with your own credentials. So if you go to StudentLoanify.com, you do not need to create an account. Just hit the login button, and you'll be able to access it. You'll also get a link to StudentLoanify right from inside the DMM portal. You'll see that as well. And again, because most of you are in our bankruptcy mortgage modification programs, just to give you a heads up, for the last several months, we have been speaking with judges, trustees, and other folks at various courthouses who are interested in implementing similar programs to the mortgage modification program to student loans within the context of the bankruptcy itself. As Josh spoke about earlier, there is an opportunity to get onto the IDRs in bankruptcy these days. The U.S. attorneys just about 6-7 months ago published some guidance where they said that is permissible. Ed Boltz has been one of the folks leading the charge on that, and Josh alluded to some language called the Buchanan language, which permits that and sets the parameters as to how you do it. And many of your courts are currently talking about implementing these programs, and hopefully by some point in 2019, you'll see some of them start to launch nationwide, and you'll have not only sort of the systems in place, but you'll also have a court structure in place as well that will enable you to do student loans and get your folks on IDR in the bankruptcy itself. So with that said, thank you very much for your attendance today. If you have any questions, feel free to reach out to us. You can email us at support@studentloanify.com, or you could continue to email us at support@defaultmitigation.com, and we'll be happy to get a hold of you. And also, like I said, we are recording this, so give us a couple of weeks and we'll get something up there for you so that you can watch this with your staff if you want to do that. And again, if you have any questions, let us know. Thanks again, and talk to you soon.